Miguel got to the construction site in Hialeah at 7 a.m. the same way he had every morning for 6 years. By 7:30, ICE agents had sealed every exit. By 8, 12 co-workers were loading into vans. A workplace ICE raid can happen to any business in any industry with no warning at all. But here's what almost no one tells workers, and what most employers don't understand either. ICE's authority inside the workplace is far more limited than agents want you to believe. And there's one specific document that changes everything during a raid. And we are going to get to that. The scene that plays out during a workplace raid is designed to overwhelm. Multiple vehicles, no warning, agents moving immediately to cover exits, large numbers in uniform with authority. The chaos is deliberate. Most workers freeze. Most employers don't know what to ask for or whether they even have a right to ask. That moment of confusion is exactly where understanding the law becomes the difference between going home that night and not. Let me start with what ICE can actually do when they show up. Agents can walk into the public areas of the business without a warrant. A lobby, a reception area, a parking lot, those are open to them. But the moment they want to move beyond the public space, the legal picture changes completely. To enter non-public areas of a workplace, the production floor, the kitchen, the back office, ICE needs one of two things. One, a judicial search warrant signed by a federal judge, or the employer's voluntary consent. And here is the document I mentioned at the start, the one that creates the most confusion during a raid. It is called an administrative warrant. An administrative warrant authorizes ICE to detain one specific named person. That is all it does. It does not authorize ICE to enter non-public areas of a building. It does not give agents the right to order every employee into a line for inspection. An employer who does not know the difference between an administrative warrant and a judicial warrant may allow agents through doors they were never legally entitled to cross. Your employer has more rights in this situation than most of them actually exercise. They can ask ICE agents to produce their warrant. They can read it carefully and verify that any search stays within exactly what the warrant authorizes. They can call legal counsel before cooperating. They can refuse access to non-public areas if only an administrative warrant is presented. None of that is obstruction. That is exercising legal rights that exist specifically for situations like this. What your employer cannot do is physically block agents who have a valid judicial warrant. But cooperation and obstruction are different things, and many employers don't know where that line falls until it is too late. Now let's talk about you as a worker. Regardless of your immigration status, you have rights the moment ICE enters a workplace. And the moment you forget them is the moment they stop protecting you. You have the right to remain silent. The Fifth Amendment applies to every person in the United States, regardless of immigration status. You do not have to answer questions about where you were born. You do not have to say how or when you entered the United States or what your current status is. You can say, I am exercising my right to remain silent. That sentence is enough. If an agent approaches you in a public area of the business and asks to speak with you, you can ask, am I free to go? If the answer is yes, you can leave calmly. If the answer is no, if an agent physically stops you or tells you that you are being detained, do not resist and do not run. Say clearly, I am exercising my right to remain silent and I want to speak with an attorney. Do not hand over documents you were not specifically asked to produce. Do not volunteer information about yourself or your coworkers. Have you or someone you know ever been present during a workplace ICE enforcement action? Drop a comment and tell me where in Florida it happened. I want to understand where enforcement activity is most concentrated. If you're detained, ICE will conduct an initial interview to determine whether you are eligible for a bond hearing. If bond is set a family member or a friend with legal status can pay it, and you fight your case from outside detention. That distinction, fighting from outside a facility versus from inside one, makes an enormous difference in what options are available and how long the process takes. As soon as it is safe to do so, write down everything you remember: agent names, badge numbers if visible, the order of events, what was said to you. That documentation matters if anything about the raid is later challenged. If your coworkers were detained and you were not, get them help quickly. Immigration attorneys and local immigrant rights organizations can respond rapidly to detention cases. In South Florida, resources exist specifically for this. Time is critical in detention. The sooner legal representation is involved, the more options remain open. If you were not detained, but you're afraid to go back to work, bring that fear to an attorney. Knowing your actual situation is always better than making decisions based on what you imagine might happen. If this video helped you understand what a workplace raid actually looks like, I have another video about what to do when ICE comes to your home, your rights at the door, and what agents can and cannot do, and how to protect your family in that situation. Watch that one next. And if you or someone you know is dealing with an ICE enforcement situation right now, our contact information is in the description.